Good morning, everybody. First, let us please take a moment to acknowledge that this event takes place on indigenous lands. The territory that we now know as South Florida has been the traditional homelands of the native nations, including the Tequesta and the Calusa, and today the sovereign homelands of the Seminole and Miccosukee. So today we're going to be talking about exploring reproductive rights as human rights. And this event is presented by the Václav Havel Program for Human Rights and Diplomacy, co-sponsored by the Center for Women's and Gender Studies, and the Office of the Social Justice and Inclusion, and the International Law section of the International Studies Association, and for sure the Dorothea Green Lecture Series. So approximately this event is going to take between 60 minutes and 75 minutes. Each participant will have time, to answer questions from your audience. So prepare your pens and papers if you have anything, that you'd like to ask. We have a super panel here that includes Dr. Rebecca Martinez to my left. She's the Vice Chair of Education, Department of Obstetrics and Gynecology at the Herbert Wertheim College of Medicine. She's a practicing OBGYN and an expert in bioethics. To her left is Amaryllis Garcia Perez. She's an assistant teaching professor and the director of pre-law advising and training office at the Department of Politics and International Relations. And she's an FIU expert in constitutional law. And to her left is Dr. Alexandra Cornelius, director of the Center for Women's and Gender Studies. She's an expert in history of Africa and African diaspora studies, Black motherhood, and maternal health. So before I start, I wanted to just reiterate the concept of women's rights, right, as fundamental rights. Even though we don't have international treaties, international laws that directly bind states to abide by these rules effectively, but it falls under multiple notions of human rights, fundamental rights. It falls under the rights of to live, rights to basically to health, rights to privacy, rights to manifold, right? And this has been acknowledged for more than 70 years. We've seen it in class and whatnot when we talk about women's movement to gain equality in, social equality, economic equality, political equality, and all that stuff. So today I want us to kind of deconstruct and break down that, leak that we saw regarding Roe versus Wade, right? And what impact would that have if it actually materializes? In theory, we all say we're human rights, we're humans, hence we have rights. But in practice, how would that translate? And again, even though there's no international law binding each state directly, but we want to look at it, how do we touch upon these issues? So again, in the US, we have more than 500 laws restricting abortion access in the US over the past decade. Things have been fluctuating, and it's never always progressing to the, to the best. So here, when we talk about the leaked draft of the Supreme Court majority opinion, that talks about overturning Roe versus Wade. I want to ask first, Dr. Amaryllis, if it's okay with you to tell me, what does that mean when it comes to what is Roe versus Wade? If you can elaborate a bit on that. What does it mean to have it as a constitutional law? And what impact would it have on states to have these type of rules and, regarding limiting abortion rights?
Okay. So going back to your first question, so what is Roe v. Wade? Roe v. Wade is a decision that came out from the Supreme Court in 1973 that established the right to an abortion as a fundamental right, the right to choose an abortion. And you were talking about fundamental rights. From a legal perspective, a right under the Constitution is fundamental when the Supreme Court declares it to be fundamental. So in 1973, the court specifically dealt with the issue of abortion. prior to that time, and the right to an abortion is basically a right that is part of a more general reproductive rights group, if we were to talk about it that way, and it stems from a right to privacy that was declared previously in the case of Griswold versus Connecticut in 1965, and then in Eisenstadt. Originally in Griswold, it was a marital right to privacy, so that right to privacy was within the marriage. That case dealt with the use of contraception within the marriage and receiving advice on the use of contraception within the marriage. Then in 1972, just 1 year before Roe v. Wade, the court in Eisenstadt versus Baird said, well, rights belong to individuals, not to marital entities. So therefore, the right has to belong to an individual, and declared it to be an individual right. And that became known as the right of self-autonomy. From that, we get the springboard into Roe v. Wade in 73, where the court declares the right to choose an abortion. But what the court did in Roe v. Wade is, and that's one of the critiques in the opinion in the Dobbs case, is it created a scheme of how you exercise that right. And the power to either have an abortion or not have an abortion correlates with the determination of whether there is a viable life. So viability kind of became this definition that the court set, but they created this trimester approach, right? And one of the criticisms of that is that was really a form of legislation. And that's what the court says in this opinion. And so the court set it up into 3 trimesters, broke down the gestation period into 3 trimesters, and said that they kind of projected that viability, and viability according to the court is the ability to have meaningful life outside the womb, even if supported by medical equipment, or, and the doctor will probably talk a little bit more about that. But that was the legal definition the court gave. So they estimated at the time that viability would be at the 3rd trimester. So the way the court laid it out in Roe was within the 1st trimester, there could be no regulations. States could not regulate. They could require that a licensed physician perform the abortion. The reason for that is what we're protecting is the life of the mother. There is no other life that is recognized. In the 2nd trimester, they'll allow states to, under Roe, to have laws, again, to protect the life of the mother, and obviously to have that licensed physician. But by the 3rd trimester, the court said, because now we are recognizing the existence of a viable life, then you can regulate and you can prohibit. That's what we had in Roe. The declaration of the right, and then this scheme that said how we can exercise the right and when you can exercise the right. But Roe hasn't existed in that true format for a very long time. So the right was changed. As early as 1989, there was a case of Webster versus Reproductive Services, where you have the dissent in Roe becoming part of the majority. It was plurality opinion, it wasn't a majority. But what happened there is the court said, well, we're gonna allow a viability test at 20 weeks. Well, 20 weeks is in the 2nd trimester. So technically, Roe started to disintegrate there. And then obviously in the Casey case, which is the case that is the legal precedent up to the time that the court finally makes a final decision, this opinion that we have was leaked, but it is not certified as the opinion of the court yet. So what happened in Casey is the court said, we think that this trimester approach is not good, and they abandoned it. They specifically say within the opinion, we're abandoning the trimester approach. So they simplified it and they said, here's how it's gonna work. We're gonna have a line at viability. Before viability, states can regulate so long as it is not a substantial obstacle, the legal term being undue burden. So the court said, if the laws you're going to make are going to make it so difficult to have an abortion that a person would choose not to have it, a woman, then at that point, then that law would be an undue burden. After viability, it stays the same as Roe. That's what the court called the essential Roe. So that's what remained of Roe and remains until today, is that prior to viability, you can have certain regulations. To give you examples, regulations that have been approved include the 24-hour waiting period, the informed consent, information about adoption, alternatives to abortion. Those things have been approved because the court recognized in Casey that the state does have an interest in that unborn life, but that interest is not greater than that of the mother. Once you have viability, then under Roe, you can prohibit. So where we are right now, still waiting on the final decision from the court on this case, is that before viability, certain regulations are approved so long as they are not an undue burden, and post-viability, you can prohibit. So states have been operating under that scheme since Casey was decided in 1992. And that's kind of where we are now. What the court is going to do with this, and I guess we'll talk about that later, is the court is going to undo, if this opinion, and I say that with a grain of salt because we don't know if the court, if this is going to be the final opinion. And so, you know, this opinion goes into great detail in outlining the historical context, not only of Roe v. Wade, but of abortion laws in general, of abortion in the United States way prior to Roe. And the court goes through all that history and other cases that we've had where the court has departed from prior legal precedent, and also in cases dealing with, interesting, one of the main cases that the court focuses on in its opinion here is the Glucksberg case, which deals with physician-assisted suicide, and equates in many ways the court saying that's not a fundamental right. So what we anticipate from this ruling, if it were to be the same, is that what will happen is that the court has said that it is no longer a fundamental right. And there was, you know, there's always been debate about whether it was even a fundamental right after Roe. Once we had Casey and you got rid of the standard is just undue burden, there was a lot of legal analysts that were saying it was no longer a fundamental right back then. So, and the impact on the states, I think that wrote my note, your last question, would be that at this point then there would be no federal mandate because there would be no fundamental rights. So the way fundamental rights work, just real brief, is that once a right is declared to be fundamental under the 14th Amendment, by way, in this case, they were claiming due process, the states would have to abide by it. The same way the right to choose to marry someone of a different race, someone of the same sex, has been declared to be fundamental. That means states can't make laws that deny you that right. So when the court goes back and says this is no longer a fundamental right, then states no longer have to, there's no federal mandate, and therefore states can regulate it as they choose.
Yeah.
Maybe that was more than you wanted.
No, that's awesome, because currently there is a case that started in December 21, Dobbs versus Jackson in Mississippi, and basically because they were trying to ban abortion after 15 weeks, and which pushed it to the Supreme Court, and now we're waiting, hopefully by the end of June, to find what is the verdict regarding that. So definitely, it's very interesting that you highlighted, you know, in 1979, how it was seen as a trimester thing, and then things are kind of rolling back. And definitely, it would be, you know, something to look for regarding if they're gonna overturn it or not.
Well, according to this decision, it would be overturned. Okay. If this is final.
Yeah. Well, yeah. And with that regard, you know, Dr. Alexandra Cornelius, I would like to ask you, like, with that regard, like with Roe versus Wade and whatnot, we think that all women, you know, face the same equal access and all that stuff. I would like to know, like, your insight as an expert regarding minority rights, intersectionality, to highlight the complexities within and what's actually happening on the ground, and how would that actually, you know, translate with the overturning Roe versus Wade.
Okay. Well, thank you so much for having us here. I really appreciate the opportunity to come and speak on these issues. I have to say, you know, I am pro-choice. I envy people who can be pro-life. I cannot be that because I just have a sense of the abject conditions under which women are making these choices. And I'm also the descendant of people who were bereft of that choice. So my understanding of this debate is really very much informed by research that I've done on enslaved women. Enslaved women were subjected, as many of you know, to an ubiquitous level of sexual violence. And so unfortunately, for people who are descendants of enslaved persons, dealing with unwanted pregnancies was very much a part of life. And we have to understand that when we talk about agency and how people are reacting to their circumstances, we really have to understand the circumstances that they're dealing with. And that's true of whether we're talking about enslaved women or women today. So for enslaved women who were not given any kind of choice in terms of being subjected to sexual violence, we have to understand that that experience involves moments of clear domination, right? That in the moment that one is being raped, there's domination, but then there's also the transition from total domination or victimhood to survival mode, right? And so how do people survive this kind of continual assault on one's humanity? And what we have to understand is that people survive in different ways, right? But ultimately try to make decisions about how they were survived. So some women in those circumstances survive by bringing to life children and loving those children and owning those children as much as they possibly could. Some of the women gave birth to children but maybe could not raise them, but were able to raise them in a community of other women, right? So we have a history of other mothering, right? Of other people taking in children. Or if women were sold away from their children, other people would take them in. But we also have women who decided that they could not live with the legacy of the rape, as it sometimes resulted in conception, right? We cannot control conception, right? We can control what happens. We can try to prevent pregnancies. We can try to actually try to make conditions good for pregnancies. We can't control conception itself. So agency has to come after the fact, right? That's just the way it is. And for some women, ending the legacy of that violent moment meant taking herbs that would then also end the pregnancy, okay? Now, so talking about women today, we also have women who are in positions where they are pregnant. The vast majority of women who are pregnant and then decide that they do not want to carry the child to term do so for financial reasons, about 75%. The next group of women who make the decision, or the most often reported reason for making that decision, is the thought that they are not ready to have the child for a number of different reasons, whether it's for professional reasons, emotional reasons, timing, so on and so forth. And then the third highest reason for not wanting to have a child to term is not wanting to be tied to the partner, whether it's because of an abusive relationship or because of some kind of something that's wrong with the relationship, and that person wants to end the relationship, and so therefore doesn't want to have a child with that person. So when there are laws set in place that prevent someone from making that kind of decision, making a decision to end or to survive in a manner that they think will be more beneficial for them, it's not only a denial of the person's ownership of the person's body, right? It's also a denial of the mind. It's a denial of the person's reasoning about their condition, their circumstances, right? Because a lot of this is based, a lot of the rationale around why people should be prevented from having abortion rests on this idea that they'll be better off, they'll recognize that this was, this was a good thing, and they'll have the child, and they love the child, and all of that. And all of that may be, in some ways, true. But what it does is it kind of diminishes the ability of the person to recognize for themselves in that moment, right, in that circumstance, what is best for them, right? What is best for her? What is best for the person, the birthing person? And so I think that in terms of human rights, of course, many organizations do appeal to human rights. Sister Song probably most famously, a reproductive rights collective that really engages women of color, appeals to and uses human rights discourse, right? And this is very much in keeping with many progressive communities, African American intellectuals, people like Malcolm X, for example, who appealed to human rights as a way to kind of circumnavigate states' rights policies that were really very hostile to African Americans, and particularly when we're talking about the post-war and Cold War period. An appeal to human rights during that time seemed to be a strong way to try to get state and even federal governments to recognize the rights of citizens within this country. In reference to today's, to the attack on reproductive rights today, I'm not sure if human rights in and of itself is enough, because so much of what's being fought happens on the state level, right? So what we're fighting against is really a very sophisticated, long, and very deliberate and organized attempt to organize state legislatures and laws that will restrict abortions, essentially. So I think in terms of the people on the ground, I think you asked about like how are people on the ground organizing. It's not necessarily, they're not necessarily thinking in terms of human rights, but maybe thinking in terms of the ways in which many people appeal to the idea of consent, right? The idea that in the very same way that people recognize that you need a person's consent to become sexually active with them, right? It's the same way that people need to be able to consent to bringing a pregnancy to term, right? So if you're, in terms of your involvement with someone, if you're in a physical relationship, you have the right to say no. You have the right to say, I don't want to be intimate with you. The same right should be involved in terms of someone who decides that they do not want to bring a child to term. Again, there are a lot of promises made to these people who don't want to bring a child to term, promises that you'll recognize that this was a good thing. But that's really, again, a violation of the person's ability to reason for themselves what's best for themselves, right? If you have a person who wants to be sexually intimate and you say you don't want to, the person can't say to you, trust me, it's going to be great, you're going to love it, everybody loves it, my mom did it and she had me. That's ridiculous, right? The same kind of rationale, I think, applies to what women who want to end a pregnancy are being told. And I think that if we, again, acknowledge the really difficult circumstances under which many of these people are making these decisions, we have to have a little bit more compassion and understanding of why they are making the decisions that they are making. So if you, for example, are wondering about how you're going to feed the children you already have, many people who have abortions already have children, or you don't know how you're going to pay your rent because your rent went up $300 or $500 or whatever is going on in Miami these days, or you don't know, you don't have the physical capacity to even take care of more children. These are the things that I think people need to consider seriously.
100%. So many thoughts. Yeah, but moving on, right? Same thing, that same way that happens to people regarding their own pregnancy, their own choice over their own body, right? How they get homogenized and stereotyped and objectified through these laws, with taking away their, capacity to have their own choice. What happens with practitioners, health practitioners on the ground, right? When it comes to, OBGYN and kind of the medical field in teaching about, how to to have safe abortion and all that stuff. What are the implications? Like, what did, first of all, Roe versus Wade help regarding, clinic open and having access and all that stuff. And what would it happen, if it gets overturned?
So I'm going to go back and touch a couple of things, just for clearance from the OBGYN point of view. So, and I do this in reproductive policy for our medical students in second year. Abortion wasn't, and correct me if I'm wrong, abortion wasn't illegal in the 1800s. So this is something that happened sometime afterwards, and I won't get into that. You touched it a little bit, that it was a way to control women, et cetera, and women's agency. The trimester thing then became an issue because most fetuses could not survive past the second trimester. And I was in a bioethics conference, by the way, over last Thursday, because it's always on Thursday. And one of the clergy there says, well, viability will keep moving forward and lower. Viability is never going to be lower than 22, 23 weeks. We need structures of the lungs and the alveoli for it to become viability. So originally when Roe v. Wade viability was much higher than it is now. So it was somewhere in the late 20s. It is now sort of standard that at 24. No matter what technology we have, we cannot make a baby survive at 22 weeks or a fetus survive at 22 weeks. And I'm not legal, so I don't know whether to say it's good to make it viability or trimester, but most people consider viability because and this I'm going to lead it into bioethics in a second, if you don't see it coming, that fetus cannot survive outside the mother. Before 22 weeks, I don't care how good our technology is. The baby does not have alveoli or the fetus doesn't have alveoli. It cannot survive outside of the mother. And then this is the part where it leads into bioethics and autonomy. So this is my, and I hate to say, my body, and it needs to survive with me. And so from medicine point of view, somewhere in the 1950s, after World War II, after the Nuremberg trials, et cetera, we said that as patients, we are responsible for what happens to our body. We moved from Marcus Welby saying, I never saw the show, but I hear it was wonderful, that saying, what I choose for you to do is the best thing for you, the same as you said, you'll like it later. And we went from paternalism in medicine to autonomy in medicine. So little touch on bioethics. Doctors will do no harm. We will do the best for our patients, and we will let you choose. We will give you the information, and we will respect you. We respect your agency to choose what you need to, what you think it's best. Now, it is my duty as a physician to know medicine very well and to make sure that I give you the right information, but I need to respect you that this is what you have chosen for yourself and for what you want. So while the baby or the fetus inside the mom, the decision is basically the mom's, or how we see it in medicine, right? You are deciding what is best for your body. There's a lot of other things that can go wrong. If you're going to go do harm to somebody else in a psychiatric manner, you should take medicine, but then we will involve lawyers and we will involve surrogate decision making. But in general, if you are completely competent, that decision must be yours. And this is where the trimesters, the viability in trimesters come in. And I think most obstetricians believe in the viability because the law was made by lawyers, maybe not necessarily by obstetricians, but it still leads us to decide that I love my child that was inside me. I love my child that was not inside me. So I have a biological and an adopted child. But while I was pregnant, the decisions were mine to make. So the problem, and also then we step in, how do we teach? And what does that mean? So for an obstetrician, it might mean that you have chosen, and you have chosen to do this for whatever reasons. And That is not for me to pick at and decide. I can advise you that I might not think it's a great reason, but I need to give you agency and respect that you do that. So in bioethics and in medicine, we respect your choices. And that is where we lead from. But then we also have to worry about taking away everybody's respect, because we might take away the decision of a woman that is in danger. So we do know that, and we work on this project together, that it is 8 times more likely, 4 to 8, depending on the study, for an African American woman to die in childbirth. That's just our statistics. In 2022, not in 1950, in 2022. Today, when you walk out the door, the statistics remain the same. It is 4 to 8 times more likely for an African American woman to die in labor. There's medical conditions that make her more prone for her to die. If she seems to carry one of those medical conditions, she should also choose whether she should take that risk. There are a lot of medical conditions that put her at risk as she goes forward, looking from the obstetrician point of view. So I'm going to look from medicine only now. So if I need to counsel somebody, you have lupus, much higher in African American women. And you have renal disease, much higher in African American women with lupus. You have a greater risk of having a premature baby that can die, and you having preeclampsia, eclampsia, and die in labor. If that choice of having an abortion is not available when she first comes in, I am not counseling my patient appropriately. My 3 tenets in medicine, do no harm and autonomy, I take out 2. I'm done. I've taken out 2. The last one is social justice, and we can argue whether it is just to have premature baby without a mom. So right off the bat, I take off 2, and we can argue that I take off 3. So if you mute me to be able to discuss that with my patient, you have basically taken away a major right of myself as an obstetrician to appropriately counsel a patient. I'm not telling her she should have an abortion, but I need her to know what her risk factor is. She's a diabetic, and now we do really well with diabetic young kids. They can live a whole life. But guess what? If her blood level, there's this thing called hemoglobin A1C, is over 11 when she is pregnant, she has a really high chance of having a malformed child. If I can't discuss that with her, if she doesn't have an option for that, I am not giving appropriate medical care, and I'm not giving her the most important thing that we value in medicine, informed consent. So informed consent is for you to make a decision, you need to know all the facts. So the facts of the good and the bad. If I only give you one version of the facts, I am not giving you informed consent. You have a broken leg, I really want to do surgery on that leg because I'm an orthopedic now, but I don't tell you you can heal just as well without the risk of surgery. I am not giving you informed consent. So we are muting our obstetricians into a lot of decision-making ability. The last thing I would like to say in reference to autonomy, et cetera, is that at the end, it is the mom's choice, and before viability, at least ACOG or the American College of OBGYN thinks that it is absolutely your choice, and it has nothing to do with my personal belief. And I need to take that away. I might never have plastic surgery, but there's a lot of my friends that are plastic surgeons that survive on plastic surgery. I should not make that judge for you or that judgment for you.
Of course. A lot of interesting facts. I would wonder, like, before Roe versus Wade, what would have been the rate of, mortality,
So, and I forgot the teaching. So it wasn't legal before the 1800s, and It became illegal to have abortion and everything's due to politics. Somewhere when Irish immigrants came into the United States, and you can please correct me if I'm wrong, somewhere when the Irish immigrants came into the United States and Catholics and they did not have abortion, the amount of Catholics were going to be a lot more, so then it became illegal because the Protestants needed to outnumber. So everything is based on something that happened. So before the 1900, it wasn't legal. Before that, it was illegal, and women figured out a way to do it anyway.
Of course.
And the number of abortions pre-Roe versus Wade was no different than the number of abortions after Roe v. Wade. It was around the million. It did not change. It just became safer. The number of abortions now is about half of what it was during Roe v. Wade. So in the 1980s, let me not go that far, in 1990s, the incidence of abortion was about 1.5 million a year. And I'm not proud of that number, but it has a lot of numbers in it, and law should not be to judge people, but allow people their agency to do what they want. But now it's down to 600 to 800. Why? Because now we get to talk about preventing abortion and preventing pregnancies, et cetera, and health care for moms that might have chosen not to have babies before is so much better. But we're still not there that we can guarantee women with illnesses that they will survive pregnancy as well. So the abortion rate did not change because of Roe v. Wade. It just became safer. The incidence of abortion now is much less than the incidence that it was in Roe v. Wade, even though it's legal. And that is the fear that how far do we push with this? And the push of viability has been, and this is a religious distinction, only when does life begin? And because of life begin, and then there's 3 religions of the book, and only one of them says that it's at conception. It happens to be my religion. I agree with it, but it doesn't mean that I do anything, because it isn't. We are a country of laws, not a country of religion. And so the incidence of abortion has gone down. What will happen to providers that need to provide an abortion? Maybe not a first trimester, but a difficult second trimester abortion, because a woman is in danger and her fetus is in danger and it's illegal. She won't be trained. She won't be trained, or they won't be trained. So we need to train our obstetricians in performing first and second trimester abortions, because sometimes not an abortion, but a fetal demise at second trimester, the procedure to terminate or to finish that pregnancy is the same. So we are looking at a lot of residencies, and they've already started going, that a lot of interns, a lot of graduating medical students will choose where they go to residency based on the state where it's in.
Definitely.
Because if you go to the most strict state in Mississippi or Texas, you won't be able to train. And then if you have to go back home and live in California or New York, you won't be trained. And you will put women's life at risk by being inappropriately trained.
And on that note, many people say that regarding, it being a constitutional law, that it should be open to democracy, it should be open to the people's vote, it should be open to the state, and hence why overturning Roe versus Wade would be more, fair for each state to make its own decisions. Could you elaborate on that, Marilis? How would that impact?
So, in terms of laws that are constitutional law in our Constitution, the Constitution is basically changed in one of 2 ways, either by amendment or by judicial interpretation. So the creation of the group of what we call non-enumerated fundamental rights, in other words, not like what we have in the Bill of Rights, where you're talking about the right against illegal searches and seizures, double jeopardy, things that are written into the Constitution. There are a group of rights which include reproductive rights, which include the right to marry, the right to refuse medical treatment, the right to raise your children according to however you see fit. Those are all rights that have come by way of judicial interpretation. The right to an abortion is one of those rights that has come by way of judicial interpretation. And they're made applicable to the states by way of the 14th Amendment, because that's really the part of the Constitution that says no state shall. So no state shall deny you a liberty. This word liberty is kind of an umbrella for all these rights. And that's one of the things that the court addresses in this opinion. And it's interesting because one of the things the court is very clear about in this opinion is that this is different from other reproductive rights. So if this decision were to become final, the court is not looking to terminate the right to use contraception. They're not looking to change, and they make a specific reference to marriage. They're not going to go back, or at least from what they say here, on their prior decisions on interracial marriage, on same-sex marriage. So the court is not looking to go back and change, as of right now, what they're saying. And they make a distinction, and that's something that I think if this were to become law, once the Supreme Court, going back to your question, says this is what something means, they're interpreting that word liberty in the 14th Amendment. So that's how we get these laws. One of the things they're saying is if you want to have regulation, the court says Roe v. Wade that opinion was like legislation. So if you want legislation, they're saying go back to your states. We're not going to we're not going to add that to the Constitution. So we have a lot of stuff, rights that we enjoy that come by way of judicial interpretation. The reason that we have integration in schools and in society is by way of judicial interpretation of the Equal Protection Clause of that 14th Amendment. But the court here it would be changing, so the term viability would no longer exist. The term that the court is using in this opinion is potential life. So everything would be based on potential life. And one of the things in listening to what you were saying, Doctor, in terms of the court using viability as a standard, one of the things, or potential life would be the new term that the court uses, is if we now have an obligation to protect that potential life, then that potential life would have its own series of rights. And so the state would then be, once you term a life to be a life, the state then has an obligation, and by the state I mean the federal government, the state government, to come and protect that. So that's where you get that distinction, and that's why Roe, that trimester, it was kind of like a springing life. So in the beginning, prior to viability, it was the mother's choice. Even after viability under Roe, to be fair, if it was a decision between the mother's life and the unborn life, then the mother's life would always take precedent, even under Roe. But what the court is saying now is that if we're looking at this potential life, then the government is going to say, the government may have a duty to come in and protect it. And therefore, that's where you get that conflict with a woman's decision and the state coming in to protect that life, which is kind of very similar to what we have with the right to refuse medical treatment being very different from the right to, and the court makes that argument. I'm just kind of echoing the arguments that are in this opinion. The difference between the right to refuse medical treatment, that self-autonomy, I don't want to be kept on life support. I have, if I have a living will, or I've made that decision, or my next of kin are going to be making that decision, I have that right as declared, and the only reason we have it is because the court declared that right and affirmed it to be fundamental in Cruzan. And the court says, well, you have a right to stop life support. You don't have a right, and in the converse argument, the court said you do not have a right to euthanasia or to physician-assisted suicide. A lot of states have said, we will give you that right. So a state can always give you more rights than the Constitution allows. They can't give you less. So there are states, and I believe Colorado is one of them, only because I've heard people go to Colorado, where that will allow that. But you don't have, and the Supreme Court uses that as to echo the argument here that says, just like you don't have a fundamental right to take affirmative action to end your life, and there's all kinds of arguments about whether removal of life support is affirmative or not. Just like we have said, the right to suicide is not a fundamental right. We feel that this right, which also would bring in a physician, is kind of in that realm. And once we feel that it is a potential life, The court is not, in this opinion, going and saying, okay, it's a trimester, it's not a trimester, it's before viability. They're just kind of saying, we're just not dealing with this at all. This belongs to states to make their decisions. Because we don't feel that it is the role of the court to be making this, creating, or not creating, because as of right now it exists, affirming this right. They feel it was incorrectly, it was bad judicial interpretation to have done this, and so they are changing that. And part of the arguments they use are, you also have the ethics of doctors that are now participating in termination of a life. And a lot of that is going to go back and forth with a definition of when life begins or when life doesn't begin. And the court has always been really careful about saying, we're not making those decisions, although potentially they kind of were, right? So what they've done now with this opinion is they've said, we've been going back and forth and trying to say, well, does life start after viability? Well, now we're going to use the term potential life. This particular law goes and says anything after 15 weeks from the first date of the last menstruation cycle, I think, is how they calculate it in Mississippi. And we have a very similar law here in Florida, actually. And so the court is saying we're kind of out of the business of determining viability, of determining anything that is, the court is not here to make issues that are really social justice issues, but you should be going to your state and having them deal with this. And this is what was being done with marriage for a very long time, until ultimately the court did go in and step in and have a federal mandate on interracial marriage and same-sex marriage. But for right now, the court is taking, what they're saying is we're taking a step back. And to go to one of the rationales that they do use is they said that before, early on, a lot of states criminalized abortion, and that is to kind of make that argument that, states should be dealing with this issue on their own. But, that goes back and forth, too, because for many years, in the Lawrence versus Texas case, which is a case that involved homosexuality and intimacy in the home, and the court said, the police can't come into your house. You have that privacy. And they went back and they reversed Bowers versus Hardwick. So the court, on the one hand is saying you still have a lot of reproductive rights in terms of contraception and things like that, although personally I think that's going to be an issue, because if you're using the term potential life, then so the court is really, rather than trying to figure this out, they are taking the position where this is really not what we're supposed to do with our constitutional interpretation, and we're stepping back and let states take care of it.
Literally, it's not our business, it's up to the states. And already we have more than 12 states ready, as soon as it gets overturned, to make it, like you said, criminalizing these acts. And
well, a lot of states have the laws.
Yeah.
They're just, now they're being challenged. So.
Exactly.
Yeah.
So on that note, how do these laws translate on the ground when, you have different people with different circumstances, not lucky enough to be in California and in other spaces? And how would that, translate on the ground, you would think, given that, the Supreme Court, the rule of law, when you said earlier that, we had to depend on international norms, international human rights. Even in Miami, we have CEDAW and all that stuff, trying to get the local to push from international norms to force their own government to do it. How would that translate on the ground when that connection stopped?
We are seeing the impact of these laws, right? Because in at least 16 states, the restrictions have become so severe that sometimes you only have one site in the state where women can get an abortion. And so women of means are able to maybe travel, right? And, if they have to travel to some place that requires a 24-hour delay or whatever have you, that's an added expense. But as has always been true, women of economic means will be better able to secure an abortion. Those who are not able to travel or are not able to travel in time, right, or to raise the funds, because that time is critical, right? And so, you have women who want to have an abortion but don't have the time to raise the money or aren't able to raise the money before the point of viability. And for insight on what happens to those people, we do have a study that was done by Diana Green Foster called the Turnaway Study. And you can look this up. This was a longitudinal study and examining surveys by over 1,100 women. And what she did was she compared the experiences of women who were able to, all of these women sought out abortions. Some of them were able to secure abortions, some of them were not because they had maybe by 3 days missed the point of viability. And she followed their experiences over at least 5 years. Out of this study came out about 50 peer-reviewed articles on various aspects of this question. So if you want more information about what this looks like, just Google Diana Green Foster, Turnaway Study. She has a book, but then there's also a website with all of the studies that were done. And what she found was that, just to highlight some of the findings, women who were turned away and went on to give birth experienced an increase in household poverty lasting at least 4 years relative to those who received an abortion. Years after an abortion denial, women were more likely to not have enough money to cover basic living expenses like food, housing, and transportation. Women who turned away from getting an abortion were more likely to stay in contact with a violent partner. They were more likely to raise children alone. Physical violence from the man involved in the pregnancy decreased for women who received abortions, but not for the women who were denied abortions and gave birth. The children of women who already had children, and the women who were not able to seek abortions, their children showed worse child development when their mother was denied an abortion compared to children of women who received one. Children born as a result of an abortion denial are more likely to live below the federal poverty level than children born from subsequent pregnancy to women who were able to sue. So they're on and on and on. These very stark kind of like real facts about what happens, not pie in the sky conjecture about, what life will be like and everything will be better, not a rosy picture, but the real stark reality of what happens to these women who are denied abortions. Now, in terms of the physical repercussions, women who were denied an abortion and gave birth reported more life-threatening complications like eclampsia and postpartum hemorrhage compared to those who received wanted abortions. Women who were denied an abortion and gave birth instead reported more chronic headaches or migraines, joint pain, gestational hypertension, and on and on. Again, the women, in their surveys, they don't say, oh, well, I regret having my child, I don't love my child, right? That's not the point of this study. What they are talking about are the real circumstances in which now they have decided, not that they decided that they had to raise their children. It was also reported that very rarely do these women give their children up for adoption, right? That's a really very rare kind of occurrence. And so again, I think in appreciating the impact of the restriction of abortions, we do have data, we do have information about what this looks like.
Yeah, and again, like what you said, like if they want to make the choice, of course they're going to make the choice. The only thing that's going to happen is either they make it in a safe space, right, where that is not criminalized. I remember there was a study about Salvador. Women literally go to jail just because of that. If somebody outs them, and it's up to the individuals, whatnot. And this is what I'm trying to figure out. Would that actually happen here? If a partner or your aggressor finds out that you're pregnant and basically you had abortion, can they call you? Do you actually go to jail? What about a medical practitioner who performed such operation, and they should have sent them out. Again, what about the bioethics there? Should I send them out or not? And what about maternal health, maternal mortality that is already a problem? You said 4 out of 8, right? So exactly. So what would happen with the increase? How would that look like? And on that point, as a an expert on that, what do you think? What do you hear around your circles? From your students? Are they like shying away from OBGYN? It's a business that is no good. What's happening with the clinics that we hear that they're closing around? How would that look like?
I don't think they're shying away from OBGYN. The amount of students going into it is large. There's less practitioner even before Roe v. Wade if you want to have a second trimester abortion, which is an abortion after 12 weeks, which are usually because of malformations, to be perfectly honest, or because of health issues. There's really only like 2 or 3 places in all of South Florida that can do it. And we send students there. So we've already have less providers that can do the difficult ones. The early one, I don't mean to belittle it, but it is much easier, and that can be done easier. But the ones that really put women at risk for already maternal complications and already for fetal complications, which is the ones over 12 weeks, when the mom finally goes to get an ultrasound at 16 weeks and it's not nice, something's happening or she's gotten sick or something, those are going to be harder and harder to obtain because they are harder now. Since I send students and providers out, there's probably only about 2 to 3 places that will do it in South Florida.
So they are shying
So
away.
it's already short of that before this Roe v. Wade. After, it will become harder. As far as if, and you can tell me the legality of it, it is going to become illegal. So I absolutely care a lot about my patients, and then you wonder, do you put your personal life at risk and your family life at risk to help somebody out? We'll see. I went to an ACOG meeting and I spoke to a provider in Texas, a male provider, and he continues to provide even though he can be turned in, and they have a fund for it, but that's all he does. That's absolutely all he does, which means that the beauty of OBGYN is the diversity of what we do. I do childbirth, I do gynecology, I do surgery, but then you're having some providers that cannot do all the other stuff because they just do that. So it's going to change who's the one that does it. There's still, as a field, we have a lot of idealists, so I'm sure a lot of providers will continue to do it like they did pre-Roe versus Wade. But it's not going to be it's not going to be the person you trust, your gynecologist.
Definitely.
So I see my patients. I've seen my patients for 30 years. I've seen them, I see their daughters, and if they need it, it won't be me,
Definitely.
right? It won't be just me. It won't be your gynecologist, because that separation will happen
Yep.
for the protection of yourself and protection of the gynecologist. So
And this is where you find predators, right? That
Right.
they're gonna take that
Right.
and take advantage of it being illicit, performing
Right,
operations.
it won't be your normal person, and it won't be, and even though I personally have chosen not to perform it, but I have somebody, it won't be the person that I normally choose to perform it, because I cannot know he does them, and he cannot, and vice versa. So we're looking at absolutely not known persons that do this. And my biggest fear is not really the first trimester, it's really the second trimester, which are the women that are at risk and the women and the fetus that have malformation, because none of that has been included as a site.
And I'm not a mother, but I've heard a lot that most people, I don't know, maybe you could tell me, that they find out that they're pregnant after the second.
Oh, the 6 weeks is ridiculous.
It's not like,
I mean,
yeah,
the 6 weeks
exactly.
means, sorry, going back to last menstrual period. If you are a regular person, that means that if you're 6 weeks pregnant, you got pregnant 2 weeks ago. If you have irregular period, 6 weeks pregnant might have mean that you got pregnant yesterday. Because we're going back to your last cycle. You're not pregnant then. You're not pregnant for those 2 weeks. Those 2 weeks when you conceived, you haven't missed your period. You still have no clue that you could or might not be pregnant. There's no pregnancy test that will tell you you're pregnant, even if you said, I'm going to do a pregnancy test every day from my day of ovulation, it won't pick it up for 10 days. And if you have cycles that are 35 days, that means at 6 weeks, you got pregnant 2 days ago.
Definitely. So yeah, it's something to think of. I would like to open it to our audience, amazing people here. If you have any questions, you already have, please do.
It's more of like a comment on the whole thing, and that. But I'm thinking about all of this together, and I'm like, wow, because the law is kind of just doing its own thing. The law, medical is doing its own thing. There's really no conversation going on holistically with everything. And I'm thinking from a psychological perspective. I'm thinking from a psychological perspective, even on the ground, that a lot of times young girls, or young women, especially in a low socioeconomic environment, they are going to be dealing with really complex decisions. Either they've been raped, or they're being physically abused by their boyfriend, or their uncle had sex with them, or there's so many reasons, that could be happening of why the girl got pregnant. And really, it seems like it's a religious conversation that's trumping the psychological, the law aspect of human rights and everything, the medical aspect. So it's just really kind of frightening, because when I think, I'm a privileged woman in a way, I have all these great choices to myself. But if I was living in Mississippi or another state as an American, I won't have those rights. And like you said, it's complicated to know when you get pregnant. If you don't have any signs, and then you eventually find out, it might be too late in that state. If you only have $20 that you make every week, especially with rising costs right now, how are you supposed to drive to get there? Especially when you have everyone around you telling you, that's not right, you're gonna kill the life, I'm gonna kill you if you go do that. There's so many social, psychological aspects that are happening during all this time, including whether or not the woman is educated properly, whether she has any information. It's just like a big bubble of a problem, and it's not as simple as just defining the law or just defining the medical aspect of it.
Thank you. Thank you.
The American Psychiatric Association was the only association that I looked into this about a couple weeks ago that made this statement, because everybody else is waiting for this to become official. So ACOG says we're not going to jump on it until this is official, but the American Psychiatric Association said that mental health in women forced to have children will increase significantly. So good for them for mentioning it and for realizing it.
Definitely. Which makes us think about the rule of law. What is the point of it? Is to help people perform the best choices that they want, or criminalize and push you away and make things illicit and whatnot. Definitely.
I mean, I think one of the things that becomes, no matter where you lie on this issue, becomes important, and I think we're seeing this on a lot of, we're going to be seeing this, I think, on a lot of issues, is that, choosing your state leaders is going to be a very important part of the way a lot of rights, whether you deem them to be fundamental or not, they're making a lot of the decisions where you're not going to be relying on the Supreme Court to be coming in and issuing federal mandates. I mean, and so I think, that's one of the things I think they're pushing for in this opinion is if it's a state issue, then you really need to be more, I think, aware of who the people that are taking these positions are and whether they align with your beliefs, and being active in really choosing state leaders becomes more important as a result of this.
So anybody who says I hate politics, think again.
You don't have a choice. You can't hate it.
Or I'm only here for this next, I'm only here for college. I won't be here in 4 years, but I vote here. Guess what? You might be here afterwards. So,
It's not somebody else's problem.
it's not somebody else's problem.
Yeah, and as you highlighted, this issue is trickling already to other aspects, which one of them I think we're going to be looking at Florida, right? The Don't Say Gay bill. What is that about and whatnot? But,
And we're going to be dealing with this with gun laws as well, even though we do have a federal mandate on gun rights. But
please.
Excellent presentation. I was in and out between office hours trying to hear you guys speak. Sometimes you guys are both. My question: having an African American my apologies for not using the mic. My question to you: having an African American woman, female, on a Supreme Court justice, do you think there'll be a difference in opinion in the future?
I certainly think that she'll represent the interests of African American women, and more than likely pro-choice mandate. But the Supreme Court doesn't rest on the opinion of one person, and so, we really have to be. The presidential elections matter. And I mean, even in the last presidential election, there was a lot of heat against Kamala Harris for who knows whatever reason. We have to be very cognizant of the extent to which our votes are not just throwaway votes, that they really do matter. Again, not only on a presidential level, but on the local levels as well. We have to be present at every election. I think, too, we have to be mindful. I mean, the Roe v. Wade, the danger to Roe v. Wade, of course, has grabbed everyone's attention. But we should also pay very close attention to the way our representatives are voting on other issues that impact women's decisions and birthing persons' decisions on whether or not they want to have children, right? So if you have someone who is adamant about who says that they are adamant about preventing abortions, but also is withdrawing funds from birth control. If you want to prevent, wouldn't you want to make sure that birth control is more accessible to people? Wouldn't you want to make sure that people have access to affordable childcare, so that if they do find themselves in a position where they want to have another child, they don't have to make a decision based on finances? Wouldn't you want to make sure that there is affordable housing available for everyone? So all of these things can go hand in hand. And in terms of holding our representatives accountable, it's not, I don't think we should think in terms of single issue, but how all of these issues work together. If someone is only willing to vote on legislation that in the end limits options for women and birthing persons, and that seems to be the common denominator, then that's at the point where I think we have to hold those representatives accountable accordingly.
Please go ahead.
So I just wanted to get your guys' opinion. I've seen a lot of articles and a lot of women are worried. There are a lot of women that are worried. Let's say once they get an abortion and it's seen as a criminal act and they go to jail, in a lot of states, once you have a criminal record, you're not allowed to vote anymore. Like, you don't have the right to vote because you're seen as a felon. And I just want to get your opinion on that.
Well, I'm not a criminal lawyer, so I'm going to abstain from a lot of that because it's going to depend, I guess, to what level it criminalizes, and there's only, what conviction for what crimes lead to deprivation of your civil rights. So I'm not really, that's not my area. But yeah, I mean, I guess if it becomes a crime, and you have to look at the particular statute in each state to see what the consequences are going to be. to that criminalization. So you would have to look and see, and then, yeah, that would be a real concern like with anything else. But I think you brought up a very good point that, you also have to then start thinking about, well, we need to work on our, foster care system. We need to work on a lot of things that will, help just overall in making situations better for women that are forced to make these decisions for a myriad of issues, as she explained, and so it's a big restructuring, because if this is what it is, that doesn't mean you just you still have to try and take care of the bigger problem, and so I think being aware of all the different aspects of it, including the criminalization and all of that, becomes important, and how we choose the people that are making these decisions. It's one of the things that I think we're going to see from the court, just as we saw. We were talking about this earlier today with Professor about the Warren era, and where you had areas where we saw promotion of civil rights cases and trying to create these unenumerated rights. We may be seeing a tendency now where the court starts stepping back and saying, this is not our role, and start throwing more to states. And if more of our rights are going to be dependent upon our state leaders, then there's more of an onus on us to really be more responsible in how we choose the people that are writing the laws. That, the reality is most of us are not going to be dealing with the federal government a whole lot in terms of our rights. Yeah, Social Security, IRS. But most of the stuff that we deal with when we interact with the law is with our state officials, right? We get stopped for speeding. We deal with buying a house. We get sued for a car accident. All of these things are controlled by state law, not by federal law. So I think if nothing else comes, and a lot will come out of this, but is that we really need to take more responsibility for choosing the people that are going to make those decisions that we feel are going to benefit us as a whole, across the board.
I also fear that that people from vulnerable communities, African Americans, people of African descent, maybe some Latinx communities, will be criminalized at a higher rate than others, right? Because that's just how, just generally speaking, we are criminalized at a higher rate.
No.
Right? So I'm from Brooklyn, New York. I didn't jaywalk, right? Because I was always afraid of getting arrested. I knew that there were things that my friends, I never smoked weed. I was so afraid of being arrested. I knew that there were things that my friends could do, my white friends could do, that I could not risk, right? And I think this same is true here. I noticed that people are talking about telehealth and self-managed abortions, and I worry about that as well. And I just generally speaking worry about the fact that whenever you have something that's deemed illegal and it goes underground, there's just more risk, again, particularly to people from vulnerable populations, about who will be, who they turn to when they can't turn to the people who have put them in the situation there, who are responsible for them seeking out abortions in the first place.
For sure.
So the illegality will become, and the reason that that abortion has become so decreased over the last 5-6 years has been that we have so many options of telehealth. So we have the RU40, we have Plan B, we have other options that you can do in the privacy of your home, and is considered more natural. The fear has been, and I've heard not heard, but read through the grapevine, all the way from IVF to ectopic pregnancies to Plan B, that all those things might become illegal. And it goes back to money. It goes back to health. So one particular state, I think Louisiana, when they said it would be at conception, they said, but if you have IVF baby, we're not including those. You don't believe in abortion, you don't believe in abortion. There is no difference. But then we are self-selecting the group of people that will be oppressed, right? And the people that won't have money. So in case, how does IVF have to do with abortion care? So IVF is that I want to have a baby. So I choose to have multiple eggs removed from me and fertilized, but I have a genetic disease. So instead of finding out at 16 weeks, I find out at 4 days. I can destroy that embryo. How is that not different?
Definitely.
So if I am so unfortunate that I find out when the baby's inside me, that cannot end, but, and this is my one argument, decisions are, and rules are the same regardless, and they're not really. So Louisiana actually said they will not include IVF embryos.
Go ahead.
Yeah, I had a question specifically for you. I'm currently in a world religions class, and we're learning about indigenous religions, and some of them have rituals that come with abortion and fertility. I know that a lot of the arguments are made using the 14th Amendment. Is there any other angle that we can go at in terms of separation of church and state or of freedom of religion? Is there any other way that we can defend abortion rights?
So with the separation of church and state, that really deals with the state imposing a religion. So I don't think that's kind of what you're talking about. When you started talking, immediately in my mind, I thought, well, you would have to say that, like you say, a religious ritual is part of your religion. But even with religious practices, and I would rather not call it ritual, because if it's a ritual, then it's not really a sincerely held religious belief. And that's really what the First Amendment protects, are sincerely held religious beliefs. Even with religious practices that would contradict so you can say, as part of my religion, I have to kill the last born, right? That would not be sanctioned by the law, because you would be committing a crime. So if your state were to criminalize a particular act, then you can't say that I have to do this as part of my religious practice. But I mean, anything can be brought up as a case. You can always say that's part of, but you get into that conflict where if the activity has been criminalized, then, and there's been case law with Jehovah's Witnesses and issues with that, where the court has sanctioned, no, we're not gonna prove that. The doctor could probably talk more on that.
And you can't belong to a religion that we don't treat asthmatics, or that you have a child that has leukemia and you refuse to have them treated. The state has always stepped in. So you have religious freedom for yourself. You don't have religious freedom for other beings. And the way they're treating this abortion right in particular is that they are, even though they're not necessarily saying, they're giving personhood to the fetus. So then and that's the whole argument.
That's the whole thing. So
and that's the whole argument. Because if you are Jewish, there is no life until you take a breath. So in Judaism, life begins, and I forget that quote because I did study religion, and I'm a bad person now because I don't remember all of it. But somewhere in the Bible, there's a thing, you become person when I breathe life into you, which means the baby comes out and breathes. And that's important sometimes when we have fetuses die, embryo, whether they can be buried or not, so it goes into all sorts. So, yeah, they're going into, and that's part of the argument, and if you're Muslim, I think it's 10 or 15 days after birth when you're named. So they're really going at making the fetus a personhood, and I think it's intentional to sort of avoid the religion of it.
Well, I think even back at Roe v. Wade, the whole idea was, and when it's a fundamental right, then the state has to have a very good reason to, and and here's the other aspect of it. So when you're talking about a fundamental right, no fundamental right is absolute, right? That's why we have death penalty here in the state of Florida is sanctioned. Your most basic of fundamental right, and my students are tired of hearing me say this, but your most basic fundamental right is your right to life. That can be taken away by the state if it deems that you've done certain things. We have Nicholas Cruz right now that they're trying to find a jury for the sentencing, right? And death penalty is on the table. So they could sentence him to death. So no fundamental right is absolute. The state can't take away every single one of them, but they have to have a very good reason. Under law, that's called compelling. So once you declare something to be a fundamental right, in order for the state to take it away, they have to have a very good reason. In the case of a child, if the child comes to the hospital and the doctor determines that these parents are not taking good care of them, then, they will come in and remove the child from the home, and there's a dependency proceeding, and those parental rights can be terminated because the government has an obligation to step in and protect that life. Right? Just like they have important to protect in a domestic violence situation. They'll come in and they'll remove whoever is the aggressor. The idea is that when you have a fundamental right, the government has to have a really good reason to take it away. When you declare a right not to be fundamental, then all they have to prove is the policy is rationally related to a legitimate governmental purpose, which is what the ruling would be in this Dobbs case. In evaluating the Mississippi law, the court said, we feel that then these laws regarding abortion or become health and welfare laws. And so they are characterized no longer as a fundamental right, but as a health and welfare law. And if they feel that it's a reasonable law in protecting health and welfare, then it will be sanctioned. And that would be the case with anything. So that is not a fundamental right. The standard is much lower than a fundamental right. So if the court is kind of not saying, we're going to say, it's a person or it's not a person, they're going to say, your state is going to make that determination. And if your state is making that determination at week 15, like is the case here, then the state will make its laws to do that. But ultimately, yes, they in Roe v. Wade and Casey, just using viability before and after, they're all definitions of your personhood. Because once there is a person, the government has a duty to protect it, just like they would a child in a home where there is abuse. The state will come in and remove that child, and they're taking away a fundamental right. They're taking that parent's fundamental right to be with their child. But they have a really good reason, which is protection of that life of that child. So if you extend that argument into what the court defines here, the court says the abortion is unique, and it's different from all other rights. So it's different from the right to care for your children, the right to marry. They're saying this one is unique because it involves a potential right. That's like to summarize this opinion. It's unique because it involves a potential life, and therefore, we're not going to rule on this. The states are going to have to make those policies.
And that's what's interesting, them making it not a fundamental right, because it goes back to when we talk about women's rights, the fight, la lucha, the movements, all that stuff that they've been doing. We have international women's rights, we have international treaties, we have, commitments, even though the United States is not part of CEDAW, but let's say Miami-Dade is part of it, These are the established norms. Women's right to her life, women's right to her health, women's right to her privacy. It wasn't something that fell from the sky, it's something that they fought for. And suddenly, like magic, well, this is not actually fundamental.
Because it has to be a fundamental right in the Constitution.
Yes.
And so should they be
the
premised on
importance
a
of
lot
it.
of that, of course, but that's really the distinction. They're saying this isn't written into our Constitution, and we don't think it's part of the words that are written into our Constitution.
Right. And also, to a certain extent, for some women, those rights were never respected and still aren't respected. So there's a slippery slope there as well. I think all women are have challenges in terms of being respected and their autonomy respected, but again, in terms of people of African descent, indigenous population, indigenous women also have really very high maternal birth rates. Any group of people who have been dominated or colonized live with this legacy of not having their personhood respected as a result of centuries of an attempt to dehumanize and to render people as less than human.
Exactly.
And so that doesn't go away overnight too, but we're all tied to this legacy.
Yeah.
And the court is just basically saying we're not going to deal in social issues.
Right.
Sorry, that's a great point that you just made, because what we're basically saying is that, well, your baby has more personhood than you do. And by doing that, forcing the woman to have a child, you're also putting that same weight on that child when they become a young woman or an adult. And the same thing will happen to them because they're growing up in poverty, they're growing up with less choices, they're growing up with all those things they have to deal with that their mother dealt with. Not only the psychological conditioning of all that, and saying, well, this is how it's done, so I'm just going to remain under this oppression. So it's a big kind of cycle of a problem if we continue down this road and allow this to happen.
Thank you. Go ahead. Oh.
Yes. So I guess going back to the separation of church and state, I know you all spoke about the individual's rights to religion, but is there an argument to be made for that, for the fact that now that this is going to be on the hands of the states to decide, a lot of these states, or at least these state representatives, have been very vocal about the fact that a lot of them are very religious. And is there an argument to be made for those people that are authoring or co-authoring these legislative decisions from a religious perspective? You know, because can we challenge that legislation that is coming not from aside from like the law, but it's more coming from the author's personal religious beliefs?
Interesting.
Well, then I think at that point, you also have the opportunity to challenge laws at a state level, and what rights your state can give you more rights, like I said. So just using an analogy of the gun rights, a lot of states have open carry laws, right, where you can we don't have that here, but you can carry a gun visibly in a restaurant, in a movie theater, or whatever. And so states will give you that right. That right is not necessarily protected by our fundamental right under the Second Amendment to bear arms. And that's a whole other, we can have a whole other meeting about that. But the idea is, the laws that our legislators make still have to conform with our Florida Constitution. And our Florida Constitution, to use Florida as an example, give us a list of rights. And so one of the things is, you can challenge those laws that are made as unconstitutional. And we have a Florida Supreme Court that would have to look at those and see, are they unconstitutional? But it's really hard to prove that a person's motivation for enacting a law is, if the law is legal, the motivation really, we can't control that, right? Again, it goes back to then choose the people that you think will be making laws based upon, good legal analysis, and feeling that it will help the public in general, not just favor one. So it really goes back to not only choosing the right people, but especially for all of you that are young, I'm too old, but you can start, run for office and really take your civic responsibilities very seriously, because it's no longer, like what I said before, somebody else's problem. And, what are we going to be doing? Moving to one state because we like this law and moving to another state because we like that law? So it's really important to take responsibility. But to go to your question, it's really hard to control people's motivations. I don't know that we could do that. But, take a look at the Florida Constitution. Take a look at what constitution you have in whatever state you're in, and see what rights you're granted in those laws. Because the only way a constitution can be changed, it's by amendment or judicial interpretation. So you still have a judicial body at the head of every state.
Exactly.
So I think what comes from this opinion is the Supreme Court saying, this is not going to be us deciding these issues anymore.
So now you know what's your assignment. Know who's your representative. There's election coming. But yes.
There's an election coming, exactly.
Exactly.
We can't all
And it's
sit
very
back
important.
and do nothing anymore.
Yeah, and the homework is not like, are they nice, they knocked on my door, they were not, but get to know more, like they were stating, why are they for this cause? Who's funding them? It's all public information.
And even at a local level, who's giving resources
Exactly.
to underserved communities? Why aren't they having the resources that they need? That becomes really important.
Yep.
I mean, I've worked briefly within the dependency process, and it, that's a reality check. You go to dependency court and you see children that are removed from the home, and all the stuff that's going on, and we have some very serious issues that can be addressed, and so.
Any final thought? Well, I would like to thank you for coming here and inspiring us, enlightening us about that issue. And with that, please give them a round of applause.
Thank you.
Thank you so much.
Thank you.
Well, have a good day.
Go change the world.
Yeah.
I'm not joking. That's your next
Put
assignment.
it on your list
FYI.
of